One is that there must exist exceptional circumstances. Exceptional circumstances for the applicant to want to detain the respondent. Your Honor, you have been told there are other people that are yet to be arrested. There is suspicion that other people were involved. From the deponent's own averments.
And the respondent should be released forthwith. That's all, Your Honor.
All right.
Your Honor, may I?
Oh, you want to say something?
Yes, and let me say something.
Can you remind me your name?
Yes, Ms. Sophie Nekesa, Your Honor.
Okay.
I will be very brief, Your Honor. I want to deal with the applicant's reasons for detention.
Okay.
As defined from paragraphs 31, from paragraphs 24 up to paragraph 31. Your Honor, those are the reasons the applicant has put forth to this court as for the reasons for the need to detain the respondent herein. Your Honor, my submission is that all those reasons listed from paragraph 24 to paragraph 31, for all those reasons that they have listed, they do not need the respondent for that. Your Honor, this matter, or rather, my submissions are based on the authority which I have served the DPP, Betty Jemtai. This is a miscellaneous criminal application. Betty Jemtai Kimeyo versus the Republic. This is a miscellaneous criminal application number 26 of 2018. Your Honor, there are three things, or rather three important action points that I wish to address from this authority.
Yes.
Miscellaneous criminal application number 26 of 2018. Betty Jemtai here. So, Your Honor, paragraph 7 of that authority, the court is saying the respondent can be detained based on the available evidence. Available evidence are the wordings of that paragraph, Your Honor. It has already been shown from the supporting affidavit of the applicant. No evidence has been shown to this court, and therefore they are mere averments. It has not been shown, Your Honor, paragraph 9 of that authority, the reason as to why the respondent might be detained further. The prosecution needs to show that the suspect is a flight risk or is likely to escape or is likely to interfere with the witnesses. Your Honor, even from the supporting affidavit of the applicant, they have not averred to that effect. There is nowhere the applicant is saying the respondent is a flight risk or is likely to escape. And number one reason why the respondent is not a flight risk, why he is not likely to escape, and why they did not put that in their supporting affidavit is because the respondent is a serving police officer, Your Honor. He cannot escape and leave his job. That is what he does for a living. That is what sustains him and his family. There are averments to the effect that the respondent might interfere with witnesses. Your Honor, paragraph 3 of the supporting affidavit of the applicant. The applicant says they have already interrogated some witnesses. So when at paragraph 30 they say they will already interfere with witnesses, we are wondering if who are these witnesses that are yet to be interrogated? Because at one point they will interfere with the witnesses, at another point we have interrogated the witnesses. So where is the truth? If anything, Your Honor, this is a police corporal. Constable, apologies, Your Honor, is a police constable. It cannot be true when the applicant says he is a police officer. That is paragraph 32 of the supporting of affidavit. It cannot be said that the police officer wields police powers. There is a likelihood the respondent did. Your Honor, that just goes on to show that there is no evidence. Like my senior put it, they are mere apprehensions. There is no any evidence whatsoever that has been brought to this court to support their averments, and therefore they are mere statements which cannot be proved. So the conclusion of that authority, that is paragraph 14, and this is the action of this authority, Your Honor. I do not find that the police offered good reasons for the continued detention of the arrested person, because the matters they used to justify the detention, taking witness statements, obtaining call data, securing forensic report, those are things that can be accomplished by the applicant without the physical need for the respondent. And that is why, Your Honor, we are asking that the application be disallowed, because the respondent is not physically needed for the applicant to carry out his duties. Now, Your Honor, there is a test that was established in the celebrated case of Oscar Sudi that my senior briefly touched on. This is Oscar Sudi Oscar Kipchumba versus the Republic. It's a criminal revision number 208 of 2020. Your Honor, in this case, there's established a double test that must be passed by the applicants for them to be able to detain the respondent. And these are the two tests, Your Honor. When he was here, he said some of the people are policemen and some are not policemen. If there are people who are involved together with the respondent, Your Honor, and they are not here, we do not know the extent of their involvement in this matter. So why would it be that the detention of the respondent is exceptional? Our submission on that, Your Honor, is that it is not an exceptional circumstance to want to detain the respondent. Number two, Your Honor, the second limb of the double test is the need for the applicant to use the least restrictive means